Okay. Okay. Um, let's now start with section number 39 and 40. Even in fact, in this session, we can complete 38 also. Okay. In the previous session, we completed 34, 35, 36, 37 of Companies Act 2013. Today, in this particular video, I'll try to cover up 38, 39, 40. Okay, these are the three sections I am going to take up in this video. A short video. I'll try to keep this sections as simple as possible through my notes. Okay, it is very important. Done. So 39, 40, every time there will be a question from this area. Okay, 38 it is not so important section, but 39, 40 both are very important. For that reason, I am starting with section number 39 itself. Okay, then I'll move on to 40, then I'll come back to 38. Done. 39, I'll try to keep the section as simple as possible. Okay, 39, it is allotment of securities. Let us now have some brief knowledge of allotment. So first of all, company before it makes the public offer, it needs to issue what? Prospectus. It needs to issue prospectus to public. Okay, inviting the public to subscribe the securities of the company. It acts as what? Invitation to offer. It acts as invitation to offer. Okay, then public will react to the invitation. They will do what? They will make application. They will make application. In fact, in Indian contract terms, Indian Contract Act terms, we can call this application as offer given by the public to company to allot the securities. Okay, now this company may accept the application, may accept the offer. It is called as allotment. In simple contract terms, we can call it as acceptance. Offer, when it is accepted, it becomes contract. Okay, this is acceptance. So invitation to offer, first one, offer, second one, and allotment, it is third one. The application, when it is accepted, it becomes allotment. So when a company needs to allot, this is what we are going to learn in section number 39. We are not focusing on remaining aspects. We are not focusing on prospectus. We are now focusing on allotment. When a company needs to allot the securities, this is what we are going to learn in this section called section number 39. Let us now try to understand this section. A company shall not allot the securities, unless both the conditions are satisfied. When these two conditions are satisfied, company is now going to allot the securities. If these two conditions are not satisfied, then there is no case of allotting the securities. This point number 3 is possible only when the following conditions are satisfied. Point number 1, it is when the company issues the prospectus, in this prospectus itself, it needs to be written that minimum subscription. Say for example, if 1 lakh shares are issued by the company, there may be three cases. 1, company may receive 1,20,000 applications, or company may receive 1 lakh applications, or company may receive 80,000 applications. The first instance is called as over subscription. This is equal subscription. And third case, it is under subscription. Under subscription. Over subscription, you can allot the securities. Equal subscription, you can allot the securities. Over subscription case, you need to follow pro rata basis. But in the last case, under subscription case, there may be an instance of non-allotment of securities also. Say, when the prospectus is issued, in that prospectus itself, we need to write the minimum subscription. Say, for example, if the minimum subscription is 80%, say in this example, I will take 90% as minimum subscription, which is written in prospectus. But in my example, under subscription happens and only 80,000 applications I received. Now you tell me, is this minimum subscription which is to be there for the purpose of allotment, is it obtained? No. 90% of 1 lakh, it becomes 90,000. Minimum 90,000 applications for the security shall be received by the company. However, only 80,000 it is received. So it is the under subscription case which is less than the minimum subscription which is there in the prospectus, and hence allotment is not possible. possible. This is the first condition you need to understand. So to allot, the first condition must be minimum subscription as specified in the prospectus must be achieved. This is point number 1. And whoever have subscribed, they have to pay the application money also. This is the second condition. See, second condition, whoever have submitted the applications, they need to pay application money in respect of minimum subscription. So minimum subscription must be there, and application money in respect of the minimum subscription shall also be received by the company, and that too other than cash. It may be by way of check, or it may be other instrument, a banking channel. Simply it can be a banking channel. Okay, it shall not be by way of cash. Okay, this is point number 2. When these two conditions are satisfied, go and allot the securities to the investors. And come to point number 3. Okay, other provisions under this section, that is rule number 11. So what can be the application money? So in the second point, we have learned something called as application money that shall be received. Now, how much should be the application money? This is the next point. Okay, application money shall not be less than 5% of the nominal amount. Say for example, the nominal amount of the share is 100 rupees. Then application money must be at least 5%. It must be 5 or more. Okay, or such other percentage as may be specified by SEBI. Okay, the time limit for getting the minimum subscription. Once the prospectus is issued, okay, minimum subscription shall be received by the company in how many days? This is what called as time limit for minimum subscription. It is 30 days of issue of prospectus or period specified by SEBI. If the minimum subscription is not received within 30 days, then all the monies which are received by the company, okay, shall be refunded. All the monies means application money. Okay, application money shall be refunded within 15 days of the closure of the issue. Within 15 days. And if there is any default of making the refund within 15 days, then obviously all the directors are jointly and severally liable to repay the entire amount along with the interest, that is 15% per annum. This is 15% per annum, which is very, very important. Once the minimum subscription is received and application money is received by way of check or other instruments, okay, and the allotment is made, then the company shall file the return of allotment to ROC. Then the company shall file the return of allotment to ROC, okay, after the allotment is done. If there is any default, okay, then the company and officer, okay, they are liable for 1000 rupees for each day of default, okay, or 1 lakh rupees, whichever is lower. And obviously, okay, initially when we collect the money, when the company collects the application money, it is collected by of banking channel. So to the same account, when it is refunded to the same account, we need to refund the same amount. Okay, here we talked about refund rate. Refund to which account the refund shall be made? Okay, from the same account from where we received the money, to the same account we need to refund the same. This is section number 39 in brief. Okay, this is a quick revision for section number 39. Let us go to section number 40 also and try to complete the section as soon as possible. That is section number 40. Okay, now section number 40. Section number 40. Shares to be dealt in, okay, stock exchange. Shares to be dealt with in stock exchange and underwriting commission. See, there may be listed companies. There may be a company which wants to make public offer. Okay, this company is public company, right? This company is public company, and this company may be listed or unlisted. Now I am talking about this listed company. There is a company which wants to offer publicly the shares. Okay, then it needs to that too this public offer shall be made, okay, through stock exchange. It desires to offer the securities through stock exchange. Then it needs to, okay, make an application. That company needs to make an application. First step, company needs to make an application to, okay, one or more recognized stock exchanges in India. Okay, see, the company needs to make an application to whom? Recognized stock exchange or exchanges. It can be one or more than one. So after making an application, those, okay, stock exchanges, need to give permission, okay, permission to the company. And those stock exchanges which have given their permission to the company, okay, the names of those stock exchanges shall be included by the company in the prospectus, okay, which is to be issued to, okay, public. Company needs to include the names of the what? Names of stock exchanges which have given the permission, and those names shall be included in the prospectus which is issued to public. Okay, these are the sequence of the steps we need to follow. First step, make an application to SE. Okay, step number 2, SE shall give the permission to the company. Step number 3, company needs to include the names of the SEs which have given the permission, and that prospectus shall be issued to public, and rest all you know. After the prospectus is issued to the public, what will happen, you know. Okay, this is point number 3. Now, see, company makes an application to one or more recognized stock exchanges for getting listed. Prospectus shall state the names of the recognized stock exchanges where the company got listed. Next one, application money shall be deposited in the separate bank account. This is as per section number 39 itself. Okay, and next one, all the money shall be utilized only for intended objects as specified in the prospectus. This also we know. Okay, when there is variation in the objects clause, then we need to comply with section number 27 also. Then, okay, when company, there is a penalty for that. Any contravention of this section is punishable under, okay, as under. The on company, minimum 5 lakhs, maximum 50 lakhs. Officer in default who failed to comply with this section, okay, who failed to comply with this section without taking the license if he offers the public, then, okay, without taking the permission or without writing the names of the stock exchanges which have given the permission in the prospectus, then these officers will be held responsible. Minimum, okay, 50,000 penalty, maximum 3 lakhs penalty, imprisonment, it was now removed, it is not there, or both is also not there. This is the final, okay, final penalty in this section, okay, and it is section number 40. Now we will talk about something called as underwriting commission. We all know something called as underwriting. Okay, when there is minimum subscription, see in our example 90% is the minimum subscription and 80% is the subscription what we got actually. Okay, there is a clear difference of 10% which is still pending to be subscribed. If this is not there, then obviously company is not going to allot the securities, company fails to get the money from the public, and company will be failed to, okay, run the business, okay, as it desires. Okay, now in this case what will happen, company needs to enter into an agreement with some person called as underwriter to avoid the instance of okay, allotment of securities. They will enter into an agreement with underwriters, okay, who will come and subscribe to this difference 10% also, which makes the actual subscription equal to minimum subscription, and hence the allotment will be there, okay, for the company. To avoid the non-allotment instances, okay, what will happen, company needs to enter into an agreement with a person called as underwriter, okay, and this underwriter will help in case of, okay, under subscription, which brings the actual subscription to minimum subscription which is required for the purpose of allotment. Okay, since he is helping the company, he charges some commission, and that commission is called as underwriting commission. Okay, and underwriting commission, okay, first of all, what will be the underwriting commission? As per the act, they have given that 5% of the issue price will be underwriting commission maximum, or in case if something is written in the AOA, say for example, if in AOA they have written a percentage called as 3%, then this 3% will be prevailed. So simply what we can say, it is 5% of the issue price or the rate which is there in AOA, whichever is lower. This is in case of what? Shares. Coming to the second side, it will be 2.5% of the issue price in case of debentures, or what? AOA rate, whichever is lower again. Okay, first of all, to enter into an agreement with underwriters, it must be authorized by AOA. The rate shall be there in, okay, AOA. So now you tell me, in AOA they have written 6%. Okay, what will be the percentage now? It will be the highest of, okay, 5% that they can give. Okay, when 5 must be compared with 3, or 5 must be compared with second instance 6%, whichever is lower we need to take. Okay, now can you, okay, Can you try to understand this? Provisions related to underwriting commission. Underwriting commission may be there only when it is authorized by AOA. This is point number 1, which is clear. And it can be paid out of free reserves or proceeds out of issue, or it can be paid out of profits of the company. So whatever the money we get from this allotment of securities, from that you can pay what? Underwriting commission. Also from the profits of the company you can pay underwriting commission. What will be the maximum underwriting commission rate you can pay? It is 5% of the issue price or the rate which is there in AOA, which is lower. In case of debentures, it is 2.5% of issue price or rate in AOA, which is lower. These are very, very important for MCQ purpose. Okay, MCQ purpose. And then in the prospectus we need to write the name of the underwriter, the rate and amount of the commission, and number of securities underwritten. It depends on the underwriting agreement. It is not there in the syllabus, but underwriting agreements are different types. There are different types of underwriting agreements. It depends on the terms of the underwriting agreements. Those terms must be disclosed in the prospectus. No underwriting commission shall be paid on the shares or other securities when it is not offered to the public. When the shares are not offered to public, so when it is not public offer, it may be the case of private company or it may be the case of public company offering private placement. It is there in section number 42. In those instances, underwriting commission is not possible. Underwriting commission is not, it is possible only when it is public offer by the public company. For them only underwriting commission is applicable. Public company issuing private placement, underwriting commission is not possible. Next one, underwriting agreement shall be delivered to ROC at the time of delivery of the prospectus for the registration. And we all know prospectus, before it is being issued to public, it must be sent to registrar, ROC. To ROC the prospectus shall be issued. At the same time, underwriting agreement shall also be given to ROC. Underwriting agreement shall also be given to ROC. This is section number 40. I try to complete section number 40 as soon as possible. It is important for MCQ purpose. Let us now try to go to section number 38 also, and quickly we will complete section number 38. A person shall be liable under section number 447. Let us read the heading also. Section number 37. Punishment for personation. Personation is nothing but duplication. You are trying to imitate someone. You are not the actual owner. You are trying to imitate the actual owner and trying to get the advantage of the shares. If you are doing this, fraudulently, then which section will be applicable? Section number 447 will be applicable. A person shall be liable under section number 447 if he makes or abets ante it is trying, trying or helping, he or he is helping to someone in making an application for the securities in fictitious name. Fictitious name is fake name. The original person is not there, but he is making some fictitious name, and in the fictitious name he is actually trying to subscribe the securities of the company. Come to point number 2. Makes or abets in making applications more than one in the name or different combination of his or surname. What he is trying to do? He is trying to make an application to the company in the name of Ravikiran Balla, or in the name of again in the name of Balla Ravikiran, again in the name of Balla Kiran Ravi, again in the name of Ravi. It is not RAVI, it is RAVEE. He is now trying to keep different combinations in his own name, and he is trying to make an application to the company to get the shares, to get allotted. If he tries to do the same, then 447 will be applicable. This is second point. And try to understand the last point. If he induces a company to allot or register the transfer of securities to him or any other person in the fictitious name. Now what he is trying to do? Mr. A, there is one person who is the existing shareholder. He is inducing the company to transfer his securities to a person who is not at all in existence. Fictitious person. He is trying to induce the company. He is trying to contact the company to transfer the shares which are there in his name to a person who is not there. To a fictitious name he is trying to transfer the shares. Then also 447 will be applicable. With this we are done with section number 38 also. Punishment for personation. Personation is duplication or faking certain person. that is called as section number 38, punishment for personation for acquisition etc of the securities. These are the three instances you need to understand, point number 1, 2 and point number 3. With this we are done with section number 38, 39 and 40 also. Let us now try to close this session now. In the next session we will try to understand rest of the chapters also. Done. So in one session around 10 to 15 minutes I'll try to cover up section number 42 also. With that we'll be completing this prospectus chapter in its entirety. Done. Thank you so much.